I want to talk about the barriers to access, especially by using contract law. And I want to say something about the way I became interested in that, and that was a couple of years ago when I was approached by one of my colleagues, and she was studying discrimination of women on sharing in the sharing economy on these platforms, and they actually sense that women getting a lower pay on online platforms, and the way they discovered it was by actually connecting to the API of one of these. It was a task one of the platforms, and collecting the data, analyzing it, getting these very interesting findings, and then wanting to publish it. And after they were analyzing it and before they published the paper, they actually received a letter from the platform. It was sometime, I think somewhere around the Cambridge Analytica scandal, and so the platform were really concerned. Everyone was consulting their lawyers, updating their terms of use, and also sending these letters that you are not allowed to use our data without our permission for any purpose. So this was not hacking research, but it was it was a legitimate research that, after data was collected, turned into something that was worrisome for the researchers. And I'll come back to this type of, to the reason why they were so worried, but let me just say that many of us, and many researchers in social science are studying social behavior online, because that is where our civilization is, right? I mean, we are working on digital platform. That is where we exchange, that is where we make friends, that is where we develop all sorts of illnesses. That is where we can actually might be cured from illnesses. One of the interesting, you talked about health in data, and data in the health sector, but one of the interesting uses, for instance, of search engines is actually, it turned out that there are very strong correlations between the way people use search engines and some disease, so that you can predict cancer. You can predict a stroke, actually, and not by the fact that people are searching for a stroke, by the fact that they're actually, may have some minor strokes before they get a stroke, and that is actually reflected in how quickly they would actually push on the search results. And so there are a lot of things that could be actually diagnosed, studied, created from these from data that is being held by digital platform. These are your Chagit's third parties, right? This is sort of the private parties, and sometimes they're reluctant to share this information. Actually, pretty often. Actually, following Cambridge Analytica, it was also before. Digital platforms were pretty aggressive in pushing off researchers that wanted to study on their platforms, and there are obvious reasons for that. So one set of reasons are the business reasons, right? This is like their source of revenue, right? I mean, it's like a lot of their discussions on digital platforms is that they sell users to advertisers, but most of what they do is generating data and selling data and data products to either the products to third parties or the data to third parties, so third parties can actually create products like a diagnosis for stroke from that data. Another reason is that platforms want to keep their competitive advantage. One of the recent disputes, such as that dispute between LinkedIn, that is going again and again in the United States, and HiQ, a competitor that was actually scraping the profiles of people on LinkedIn that are actually open to the public, and creating a new data service that is able to predict what type of skills people need, when it is likely that an employee would leave their job. But these are, again, supplementary services. You want to prevent that, and so you hold on to your data. Other types of reasons are legal and regulatory reasons, reputational concerns. I mentioned the Cambridge Analytica scandal, but also a concern about protecting the privacy of users. Sometimes it is being used as an excuse, but definitely to keep the security of users. And maybe the most important reason is to prevent strangers from studying our platform, right? So if studies show that young women are developing anorexia or eating disorders when they engage on TikTok or on Facebook, you don't want researchers to actually study it and discover some of the harms. In terms of the legal protections that are available, data is not protected by intellectual property, as we know. So copyright law does not protect data as is. It protects aggregated data, but only to the extent that there is some originality in the aggregation, in the compilation. Usually studies are extracting only part of the data and do not trigger that type of right. And if they do, Peter talked about fair use or the other exceptions and limitations that would normally apply. Trade secrets, that might be applicable, but not when researchers are scraping publicly available information. Some courts disagree with that, but let's put it aside because this is not the focus here. Privacy, again, is an important barrier. But what made my friends really concerned is the combination of some contractual restrictions on the terms of use and this law, that is the Computer Fraud and Abuse Act in the United States, that actually prohibit, expose users to criminal liability if they make unauthorized access to computer in order to obtain information. And a researcher can think, well, if I'm violating the terms of use, I may be liable for damages, but there's not, high, level harm, so maybe I can take a chance. But if you're exposed to criminal liability, that's a completely different ballgame. And here, so contracts here came to the front seat in addressing what restrictions would apply to any access to the data. Unfortunately, I was hoping to present to you a survey that we did for terms of use in a couple of hundred platforms, comparing the different type of restrictions that they apply, but we didn't finish to analyze the data for today, so there is something to look forward to. But what is really interesting is that, as another colleague of ours, Tami Krichl-Katz from the law school, was running her research on, again, now not discrimination of women in pay, but actually different type of pricing that women will get for selling things on eBay, something that is really counterintuitive. She may actually face criminal liability and not just civil liability. And here the question that came to the court in the United States in a petition that was brought by several civil society organizations on behalf of researchers was whether, what counts as access to a computer that exceeded authorization. Is the fact that it is simply prohibited by the contract, by the terms of use, make this a criminal offense? And the court said no. Luckily, the court said that the terms of use cannot constitute permission requirements for the criminal liability. And actually something that is really interesting for those of you who are studying in social science, that you can, if you bypass the authentication permission, that could actually trigger liability, but not in the way that we normally do research. So if you sort of fake your name, you get online with a fake identity. Like if you want to check whether men and women get different prices, sometimes you have to come up as a man, right? I mean, it's like, as long as you use a password, even if it is not an authentic name and password, as long as you comply with some payment requirement. It's unclear whether when researchers are doing identity theft that would apply, but the bottom line is that the court in 2020 in the United States was actually permissible for this type of use. Further on, in a Supreme Court case that came a year after, the Supreme Court of the United States actually held in a different context, not related to research, that, but applying, interpreting the same provision, that if you enter the system with authorization, but then you use the system against the terms of use, in violation of the terms of use, this does not trigger any criminal liability. To trigger criminal liability, you actually have to pass a technical barrier. You have to hack without authorization, which makes it really interesting now that this is a rule against the designer, not against the interpreter, for those of you who study contractual. Anyway, copyright, there are several strategies to actually reinterpret these contracts and question whether the prohibition on using data in these websites for research is actually a violation now of the contract itself. It's preemption doctrine in the United States, but also different contractual interpretation strategies. But all these strategies are actually offering a shield. They do not offer a sword. They do not allow, they allow researchers to claim, well, I did not violate the contract because it's a standard from contract. It prohibits access to data, whereas data is actually, access to data is actually secured by some laws. So, but this is all shields from protection. It doesn't allow an affirmative right to access data. And here, the Europeans, with their bulimic approach to regulating the digital sphere, what we call it in another research, the digital agenda, they actually introduce a set of rules. Actually, some of them relate to Chagit's presentation about creating a market for research collaboration. These two laws, one an act already, one is still a proposal. Some rules that are creating additional sources of data, for instance, requiring platforms to provide more transparency and reports that could actually be analyzed by researchers. But most importantly is the Digital Service Act, and I'd like to spend a few minutes just discussing this. And so the Digital Service Act, that was actually came into effect in November 2022, a couple of months ago, create a compulsory regime applied to these elephants, right? To very large online platforms and very large online search engines. So it doesn't apply to the small little platform like a dating app. It does apply to the major platforms that we know. And it actually creates a mechanism by which researchers can demand access to data. The principles are that this applies to vetted researchers. That would include academics and universities and academic institutions, journalists. It creates the procedures for exercising the right. I will say a few words about this in a minute. And a new regulatory agency that is actually deciding on these disputes, whether you should or you shouldn't get access to this data. And so you can see this, the complexity of this system, but basically you have to qualify as a researcher. You have to, in order to do that, you have to apply to the new institution that was created in the great tradition, European tradition, they create new institutions. And that would be national institutions. It can actually, that will be in each and every state where you have to be qualified as a researcher. And an application for a particular research request will be provided to the authority in the country where the platform is located, mostly in Ireland, where these decisions will be held. What are the limits of this new regime? One is that this new regime actually applies to research that is intended to make platforms more accountable. So the type of research that seek to establish, for instance, that young women develop eating disorders, you may get access. But to a scientific research, such as the one that I mentioned in the, first, that is about whether there is a relationship between getting a stroke and looking on for data on Google, you may not get access. So it only applies to systemic risk mitigation measures connected to platforms, but not generally applying. It lacks, importantly, the type of exploratory research that is so important for the academia. Sometimes we don't know what we are looking for. We simply want to search and then learn what it is that we are looking for. And this is a major issue that could create a barrier. And also, to be a vetted researcher, Peter mentioned before is citizen science and participation by a broader group of players that would not count here. And so, what are, let me just mention two ways to move forward. One is to expand some of the provisions in the DSA, the structure of the DSA, that the right to research is no longer a matter of contract law, but it's a matter of an institutional national decision. That is actually a good development. But to expand it so it would apply also to exploratory research. And another way to go about it is to create safe harbors for non-commercial public interest research so that my friends could feel safe. Thank you.
Thank you.